Independence in Congress, July the 4th, 1776. Preamble. When, in the course of human events, it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature and of nature's God entitles them. A decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. A new theory of government. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just power from the consent of the governed, that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such forms as to them shall seem most likely to affect their safety and happiness. Prudence, indeed, will dictate that governments long established should not be changed for light and transit clauses, and accordingly all experience hath shown that mankind are more disposed to suffer while evils are sufferable than to right themselves by abolishing the forms to which they are accustomed. But when a long train of abuses and usurpations, pursuing invariably the same object, evinces a design to reduce them under absolute despotism, it is their right, it is their duty to throw off such government and to provide new guards for their future security. Reasons for separation. Such has been the patient sufferance of these colonies, and such is now the necessity which constrains them to alter their former system of government. The history of the present King of Great Britain is a history of repeated injuries and usurpations, all having in direct object the establishment of an absolute tyranny over these states. To prove this, let facts be submitted to a candid world. He has refused his assent to law the most wholesome and necessary for the public good. He has forbidden his governors to pass laws of immediate and pressing importance, unless suspended in their operation till his assent should be obtained. And when so suspended, he has utterly neglected to attend to them. He has refused to pass other laws for the accommodation of large districts of people unless those people who relinquish the right of representation in a legislature, a right inestimable to them and formidable to tyrants only. He has called together legislative bodies at places unusual, uncomfortable, and distant from the depository of their public records, for the sole purpose of fatiguing them into compliance with his measure. He has dissolved representative houses repeatedly for opposing with manly firmness his invasion on the rights of the people. He has refused for a long time after such dissolutions to cause others to be elected, whereby the legislative powers incapable of annihilation, have returned to the people at large for their exercise. The state remaining, in the meantime, exposed to all the dangers of invasions from without and convulsions within. He has endeavored to prevent the population of these states, for that purpose obstructing the laws of naturalization of foreigners, refusing to pass others to encourage their migration hither, and raising the conditions of new appropriations of lands. He has obstructed the administration of justice by refusing his assent to laws for establishing judiciary powers. He has made judges dependent on his will alone for the tenure of their offices and the amount and payment of their salaries. He has erected a multitude of new offices and sent hither swarms of officers to harass our people and eat out their substance. He has kept among us, in time of peace, standing armies without the consent of our legislature. He has affected to render the military independent of and superior to civil power. He has combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledgeable by our laws, giving his assent to their acts of preventing legislation, for quartering large bodies of armed troops among us, for protecting them by a mock trial from punishment for any murder which they should commit on the inhabitants of these states, for cutting off our trade with all parts of the world, for imposing taxes on us without our consent, for depriving us in many ways of the benefits of trial by jury, for transporting us beyond seas to be tried for pretended offenses, for abolishing the free system of English laws in a neighboring province, establishing therein an arbitrary government and enlarging its boundaries so as to render it at once an example and fit instrument for introducing the same absolute rule unto these colonies, for taking away our charters, abolishing our most valuable laws, and altering fundamentally the forms of our government, for suspending our own legislature and declaring themselves invested with power to legislate for us in all cases whatsoever. He has abdicated government here by declaring us out of his protections and waging war against us. He has plundered our seas, ravaged our coast, burnt down our towns, and destroyed the lives of our people. He is at this time transporting large armies of foreign mercenaries to complete the works of death, desolation, of tyranny, already begun with circumstances of cruelty and perfidy scarcely paralleled in the most barbarous ages, and totally unworthy the head of a civilized nation. He has constrained our fellow citizens, taken captive on the high seas, to bear arms against their country, to become the executioners of their friends and brethren, or to pull himself by their hands. He has excited domestic insurrection among us, and has endeavored to bring on the inhabitants of our frontiers the merciless Indian savages, whose known rule of warfare is an undistinguished destruction of all ages, sex, and conditions. In every stage of these oppressions we have petitioned for redress in the most humble terms. Our repeated petitions have been answered only by a repeated injury. A prince whose character is thus marked by every act which may define a tyrant is unfit to be the ruler of a free people. Not have we been wanting in attention to our British brethren, we have warned them from time to time of attempts by their legislature to extend an unwarrantable jurisdiction over us. We have reminded them of the circumstances of our emigration and settlement here. We have appealed to their native justice and magnanimity, and to have conjured them by the ties of our common kindred to disavow these usurpations, which would inevitably interrupt our connections and correspondence. They too have been deaf to the voice of justice and of consanguinity. We must therefore acquiesce in the necessity which denounces our separation, and hold them as we hold the rest of mankind, enemies in war, and peace friends. A formal declaration of war. We, therefore, representatives of the United States of America, in General Congress assembled, appealing to the Supreme Judge of the world for the rectitude of our intentions, do, in the name and by authority of the good people of these colonies, solemnly publish and declare that these United Colonies are, and of right ought to be, free and independent states, that they are absolved from all allegiance to the British Crown, and that all political connections between them and the state of Great Britain is, and ought to be, totally dissolved, and that, as free and independent states, they have full power to levy war, conclude peace, contract allegiance, establish commerce, and to do all other acts and things which independent states may or may not do, and things which independent states may of right do, and for the support of this declaration, with a firm reliance on the protection of divine providence, we mutually pledge to each other our lives, our fortune, and our sacred honor. Signed, John Hancock, Massachusetts. For New Hampshire, Joshua Bartlett. William Whipple, Matthew Thornton. For New York, William Floyd, Philip Livingston, Francis Lewis, Lewis Morris. For Maryland, Samuel Chase, William Packer, Thomas Stone, Charles Carroll of Carrolltown. Connecticut, Roger Sherman, Samuel Huntington, William Williams, Oliver Wolcott. Virginia, George Wyatt, Richard Henry Lee, Thomas Jefferson, Benjamin Harrison, Thomas Nelson, Francis Lightfoot Lee, Carter Braxton. Massachusetts, Samuel Adams, John Adams, Robert Treat Payne, Elbridge Gerry. New Jersey, Richard Stockton, John Witherspoon, Francis Hopkins, John Hart, Abraham Clark. South Carolina, Edward Rutledge, Thomas Haywood, Thomas Lynch, Arthur Middle. Pennsylvania, Robert Morris, Benjamin Rush, Benjamin Franklin, John Morton, George Calmer, James Smith, George Taylor, James Wilson, George Ross. Georgia, Button Gwinnett, Lyman Hall, George Walton. Delaware, Caesar Rodney, George Reed. The Constitution of the United States. Preamble. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity do ordain and establish this Constitution of the United States of America. In addition to stating the purpose of the Constitution, the Preamble makes it clear that the government is established by consent of the governed. We, the people, ordain and establish the government. We, the people, have supreme power in establishing the government of the United States of America. Article 1, Legislative Department, Section 1, Congress. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. By separating the functions of government among branches concerned with law-making, Article 1, law executing. Article 2, the law interpreting. Article 3, the framers of the Constitution were applying the principle of separation of power and developing a system of checks and balance as a defense against dictatorship. Practice has modified the provisions that all law-making power granted to the Constitution shall be vested in Congress. For example, such administrative agencies as the Interstate Commerce Commission can issue regulations which in some ways have the force of law. Section 2, House of Representatives. 1. Elections and term of members. The House of Representatives shall be composed of members chosen every second year by the people of the several states, and the electors in each state shall have the qualification requested for electors of the most numerous branch of the state legislature. Members of the House of Representatives are elected every 2 years by the electors, voters, of the states, except for the provisions of Amendments 15 and 19. The individual states decide who may or may not vote. Clause 2, Qualifications. No person shall be a representative who shall not have attained the age of 25 years and been 7 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state in which he shall be chosen. Qualifications for a representative. 1. At least 25 years of age. 2. A United States citizen for at least 7 years. 3. Residence in the state in which elected. Custom has added the requirements of residence in the congressional district from which a representative is elected. Each state is divided into congressional districts for the purpose of electing representatives. Each district elects one, term of office 2 years. The 3 branches of federal government. Legislative branch. House of Representatives, membership based on state population. Senate, 2 senators from each state. Article 1 establishes the legislative branch. Standing committees of the House. Agriculture, apportionments, appropriations, armed services, banking and currency, District of Columbia, education and labor, foreign affairs, government operations, House administration, interior and insular affairs, interstate and foreign commerce, judiciary, merchant marine and fisheries, post office and civil service, public works, rules, science and astronautics, un-American activities, veteran affairs, and ways and means. At the Senate, aeronautical and space science, agriculture and forestry, appropriations, armed services, banking and currency, District of Columbia, finance, foreign relations, government operations, interior and insular affairs, judiciary, labor and public welfare, post office and civil service, public works, rules and administration. Executive branch. Article 2 establishes the executive branch. Executive departments. Heads of these departments from the President's Cabinet: Department of State, Department of the Treasury, Defense, Justice, Post Office, Interior, Agriculture, Commerce, Labor, Health, Education, and Welfare, Housing and Urban Development. The Executive Office: White House, Bureau of the Budget, Council of Economic Advisors, National Security Council, National Aeronautics and Space Council, Office of Economic Opportunity, Office of Emergency Planning, Office of Science and Technology, Office of the Special Representative of Trade Negotiation. So, Article 3 establishes the judicial branch: the Supreme Court, Court of Appeals, District Courts, Courts of the District of Columbia, Special Courts, Courts of Claim, Courts of Customs and Patent Appeals, Custom Courts, Territorial Courts, Court of Military Appeals. Clause 3. Apportionment of representatives and direct taxes. Representatives and direct taxes shall be apportioned among the several states which may be included within this union according to their representative numbers, which shall be determined by adding to the whole number of free persons, including those bound to service for a term of years, and excluding Indians not taxed, 3/5 of all other persons. The actual enumeration shall be made within 3 years after the first meeting of the Congress of the United States, and within every subsequent term of 10 years, in such manner as they shall by law direct. Number of representatives shall not exceed 1 for every 30,000, but each state shall have at least 1 representative, and until such enumeration shall be made, the state of New Hampshire shall be entitled to choose 3, Massachusetts 8, Rhode Island and Providence plantations 1, Connecticut 5, New York 6, New Jersey 4, Pennsylvania 8, Delaware 1, Maryland 6, Virginia 10, North Carolina 5, South Carolina 5, and Georgia 3. The bracket portions of this clause, beginning on line 3, forms what came to be called the 3/5 Compromise. Amendment 13 and Section 2 of Amendment 14 overruled this provision. Originally, each state was entitled to 1 representative in Congress for every 30,000 people. Later, membership was limited by law to 435. A census of the population is taken every 10 years to determine the number of representatives in each state, in which each state is entitled. Congress can change the number of members as it did temporarily when Alaska and Hawaii were admitted to the Union. Before 1960 census had determined the new numbers of representatives for each state. A state, regardless of its population, is entitled to at least 1 representative. Clause 4. Filling vacancies. When vacancies happen in the representation from any state, the executive authority thereof shall issue writ of election to fill such vacancies. Clause 5. Officers' impeachment. The House of Representatives shall choose the Speaker and other officers, and shall have the sole power of impeachment. Clause 4. The executive authority refers to the governor of the state. A writ of election is in order for a special election to fill the vacant seat. Clause 5. In actual practice, it is the majority party, the political party having the largest number of members in the House, which chooses the Speaker, Chairman of the House, and other officials: clerk, doorkeeper, sergeant-at-arms, postmaster, and chaplain. The Speaker is the only official chosen From among the members of the House by a majority vote can impeach, accuse an executive department officer or a federal judge. The trial of the impeached official takes place in the Senate. Section 3, Senate. Clause 1. Number of members and term of office. The Senate of the United States shall be composed of 2 senators from each state, chosen by the legislature thereof, for 6 years, and each senator shall have 1 vote. Under the provision of Amendment 17, the 100 senators are now elected directly by the voters of the states in the same manner as the representatives. The method of electing senators provided above, by which the state legislature choose senators, came to be considered undemocratic. Clause 2. Classification, filling vacancies. Immediately after they shall be assembled in consequence of the first election, they shall be divided as equally as may be into 3 classes. The seats of the senators of the first class shall be vacated at the expiration of the 2nd year, of the second class at the expiration of the 4th year, and the third class at the expiration of the 6th year, so that 1/3 may be chosen every 2nd year. And if vacancies happen by resignation or otherwise, during the recess of the legislature of any state, the executive thereof may make temporary appointments until the next meeting of the legislature, which shall then fill such vacancies. 1/3 of the Senate comes up for election every 2 years. This procedure was established in the first Senate, whose senators were divided into 3 groups. One group was to serve for 2 years, the second for 4 years, and the third for 6 years. As a result, the terms of senators today overlap, making the Senate a continuing body in which 2/3 of the members are carried over through every election. In contrast, the total membership of the House of Representatives is elected every 2 years. If a senator resigns or dies, the governor of the state is authorized under Amendment 17 to call a special election to fill the vacancy. The state legislature, however, may empower the governor to name a temporary senator until the next election. Clause 3, Qualification. No person shall be a senator who shall not have attained the age of 30 years, and been 9 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state for which he shall be chosen. Qualifications for a senator: at least 30 years of age. 2. A citizen for at least 9 years. 3. Residence in the state in which elected. Term of office, 6 years. President. Clause 4. President of the Senate. The Vice President of the United States shall be President of the Senate, but shall have no vote unless they be equally divided. Clause 5. Other officers. The Senate shall choose their other officers, but also a President pro tempore, in the absence of the Vice President, or when he shall exercise the office of the President of the United States. Clause 4. To serve as President of the Senate is the only duty which the Constitution assigns to the Vice President. He votes as a senator only in case of a tie. After the illness of President Eisenhower in 1956 and 57, the Vice President undertook additional duties at the President's request. He attended cabinet meetings, traveled abroad on goodwill tours, and carried out ceremonial duties, such as entertaining leading officials from abroad and representing the government at important events. Clause 5. Other officers include a secretary, chaplain, and sergeant-at-arms. These officers are not members of the Senate. Pro tempore means for the time being or temporarily. Thus, the President pro tempore acts as a temporary President of the Senate. Clause 6. Trial of impeachments. The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on an oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside. No person shall be convicted without the concurrence of 2/3 of the members present. Only the President, Vice President, Cabinet officials, and federal judges are subject to impeachment and removal from office. Members of the House and Senate cannot be impeached, but they can be censured and even removed from office by members of their respective houses. Officials may be impeached only for committing treason, bribery, or other high crimes and misdemeanors. The Chief Justice of the United States presides at the impeachment trial of a President, the Vice President, The Chief Justice of the United States presides at the impeachment trial of a President. The Vice President presides over all other impeachment trials. The Senate can find an impeachment official guilty only if 2/3 of the senators present agree on a verdict. The majority of the Senate must be present. The only president impeached was Andrew Johnson in 1867. He was saved from conviction by 1 vote. In all, the Senate has sat as a court of impeachment in 12 cases. A verdict of guilty was found in 4 of these. Clause 7. Penalty for conviction. Judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. The punishment for conviction in impeachment cases in impeachment cases can consist only of removal from office and disqualification from holding any other federal office. However, the convicted person may also be tried in regular court of law for the offense from which he was removed from office. Section 4. Elections and Meetings. Clause 1. Holding elections. The time, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. But the Congress may at any time, by law, make or alter such regulations, except as to the place of choosing senators. Clause 2. Meetings. Congress shall assemble at least once in every year, and such meetings shall be on the first Monday in December, unless they shall by law appoint a different day. Clause 1. Under this provision, Congress has passed a law stating that, unless the Constitution of a state provides otherwise, congressional elections must be held on the Tuesday following the first Monday in November. On even-numbered years, in Maine, elections are held in September. Congress has also ruled that representatives must be elected by district rather than by the state as a whole, and that secret ballots or voting machines, where required by state law, must be used. Clause 2. This clause has been changed by Amendment 20. Today, Congress meets on January the 3rd, unless it sets another day by law. Section 5. Rules of Procedure. Clause 1. Organization. Each house shall be the judge of the election returns and qualification of its own members, and a majority of each shall constitute a quorum to do business. but a small number may adjourn from day to day and may be authorized to compel the attendance of absent members in such manner and under such penalties as each house may provide. Clause 2. Proceedings. Each house may determine the rules of its proceedings, punish its members for disorderly behavior, and with the concurrence of 2/3 expel a member. Clause 1. Each House of Congress may disqualify elected candidates and preserve them from taking office and prevent them from taking office on the grounds of public policy. On one occasion, the House refused to admit to membership an elected candidate who had violated criminal laws. On another occasion, the Senate refused to seat a victorious candidate whose election campaign had been characterized by fraud and corruption. A quorum is the minimum number of persons required to represent. A quorum is the minimum number of persons required to be present to transact business. A majority of the House or Senate constitutes a quorum. In practice, business is often transacted with less than a quorum present, and may go on as long as no congressman objects to the lack of a quorum. Clause 2. Each House has extensive rules of procedure. Each House can censure, punish, or expel a member. Expulsion requires a 2/3 vote. Clause 3. Journal. Each House shall keep a journal of its proceedings. From time to time, publish the same, excepting such parts as may, in their judgment, require secrecy. The yeas and nays of the members of either House on any question shall, at the desire of 1/5 of those present, be entered on the journal. Clause 4. Adjournment. Neither House, during the session of Congress, shall, without the consent of the other, adjourn for more than 3 days, or to any other place than that in which the two houses shall be sitting. Clause 3. Each House is required to keep a journal of its activities. These journals, called the House Journal and the State Journal, are published at the end of each session of Congress. A third journal, called the Congressional Record, is published every day that Congress is in session, and furnishes a daily account of what representatives and senators do and say. If 1/5 of those present insist on a roll call of the members' votes, the vote of each member must be recorded in the proper House Journal. Clause 4. Both houses must remain in session for the same period of time and in the same place. Section 6. Privileges and restrictions. Pay and privileges. The senators and representatives shall receive a compensation for their service to be ascertained by law and paid out of the Treasury of the United States. They shall, in all cases, except treason, felony, and breach of the peace, be privileged from arrest during their attendance at the session of their respective houses, and in going to and returning from the same, and from any speech or debate in either house they shall not be questioned in any other place. In 1964, the salary of a congressman was set by law at $30,000 a year. Provision concerning privileges from arrest establishes the principle of congressional immunity. According to this principle, congressmen cannot be arrested or brought into court for what they say in speeches and debate in Congress. The aim of this provision is to enable members of Congress to speak freely. Congressmen are subject to arrest, however, if they commit a crime, and under the laws governing slander and libel, they are liable for any false or defamatory statement that they may make outside Congress. Clause 2. Restrictions. No senator or representative shall, during the time for which he was elected, be appointed to any civil office under the authority of the United States, which shall have been created, or the emoluments whereof shall have been increased during such time, and no persons holding any office under the United States shall be a member of either house during his continuance in office. This clause emphasizes the separation of powers in the federal government. Legislature cannot, while they are members of Congress, hold positions also in the executive or judicial department, nor can a legislature resign his post and accept a position which was created during his term of office. Thus, congressmen cannot set up jobs for themselves in the executive or judicial branch of the government. Furthermore, if a congressman resigns and is appointed to an existing executive or judicial position, he cannot profit from any increase in pay in this position that was voted during the term in Congress. Section 7. Methods of passing laws. Clause 1. Revenue bills. All bills for raising revenue shall originate in the House of Representatives, but the Senate may propose or concur with amendments as other bills. All revenue or money-making raising bills must be introduced in the House of Representatives. This provision grew out of a demand that the popular elected branch of the legislature shall have the power of the purse until Amendment 17 was ratified. The House of Representatives was the only popular elected branch. It was also felt that the voters had more control over representatives who are elected for 2 years' term than over senators who are elected for 6-year terms. Thus, representatives who would be more careful than the Senate in considering revenue bills, since the Senate has the power to amend any bill. However, it can amend a revenue bill in such a way as actually to introduce a revenue bill of its own. Clause 2. How a bill becomes law. Every bill which shall have been passed the House of Representatives and the Senate shall, before it becomes a law, be presented to the President of the United States. If he approved, he shall sign it. But if not, he shall return it with his objections to the House in which it shall have originated. He shall enter the objections at large on this journal and proceed to reconsider it. If after such reconsideration 2/3 of that House shall agree to pass the bill, it shall be sent together with the objections to the House, by which it shall likewise be reconsidered. And if approved by 2/3 of that House, it shall become a law. But in all such cases, the votes of both houses shall be determined by yeas and nays, and the names of the persons voting for and against the bill shall be entered on the journal of each house respectively. If any bill shall not be returned by the President within 10 days, Sunday excepted, after it shall have been presented to him, the same shall be a law in like manner as if he had signed it, unless the Congress by their adjournment prevents its return, in which case it shall not be law. How a bill becomes a law. A typical successful bill follows this course on its way to becoming a federal law. A group of citizens or private organization may have requested it, or the President may have recommended it, or a group in Congress in either the House or Senate may have believed it was needed and agreed to introduce it. The bill is drafted by one or more congressmen and introduced in the appropriate House. In this case, the House of Representatives. Bills pertaining to the raising of money must originate in the House of Representatives. Other bills may originate in the House or Senate. Number 1. A bill is introduced in the House of Representatives. House of Representatives. 2. Clerk of the House. A congressman submits bill to clerk who places it in a box called a hopper. B. Title of bill read to House members assigned. Bill printed, sent by Speaker of the House to committee concerned with the subject of the bill. 3. House Committee. A. Committee or one of its subcommittees support bill. May hold hearings, amend, rewrite, kill, or approve. D. The bill approved, committee reports bill favorably and is placed on the calendar. 4. Rules Committee. Rules Committee may push important bills ahead, may block bills it does not approve by floor of the House. A. Bill read and debated. B. Amended or returned to House Committee for revision or approved. C. If House approved bill by majority vote, it is read again and passed. Passed by the House, sent to the Senate. This is the Senate now. 6. Clerk sends bill to presiding officer of the Senate, usually the Vice President. B. Presiding officer assigns bill to appropriate committee for study. 7. Senate Committee. Procedure is similar to that in the House. 8. Senate Floor. Procedure is similar to that in the House. Step 5. If Senate disagrees with House version, bill is sent to Conference Committee of House and Senate. When passed in same form as to the House, bill goes to the President. Conference Committee irons out differences that may occur between House and Senate. Return revised bill for approval to both House and Senate. All right, when passed, the bill is passed in the same form as in the House. Bill goes to the President. 9. President. Cabinet members may be asked to advise on bill. President signs or vetoes bill, or allows it to become law without signing it. Congress can overrule veto by 2/3 votes of the House. 10. Secretary of State. A. Affixes Great Seal of the United States. B. Proclaiming that bill is now law of the land. Procedure under which a bill becomes a law is shown on the opposite page. If the President does not approve of a bill, there are several things he may do. 1. He may veto or refuse to sign the bill. 2. He may permit the bill to become a law without his signature by holding it for 10 days, not counting Sundays, while Congress is in session. 3. Toward the end of a congressional session, he may hold a bill in the hope that Congress will adjourn within 10 days or less. In that case, the bill fails to become a law, just as though the President had formally vetoed it. This type of veto is called a pocket veto. A bill vetoed by the President can become a law despite his objections. 2/3 or more of both houses vote for the bill a second time. When this happens, Congress is said to have overridden the presidential veto. Clause 3. Presidential approval or veto. Every order, resolution, or vote to which the concurrence of the State and House of Representatives may be necessary, except on a question of adjournment, shall be presented to the President of the United States, and before the same shall take effect, shall be approved by him, or be disapproved by him, shall be passed by 2/3 of the Senate and House of Representatives, according to the rules and limitations prescribed in the case of the bill. A joint resolution results from declaration passed by both houses of Congress on the same subject. It becomes a law in the same manner as a bill. A congressional declaration of war takes the form of a joint resolution. A concurrent resolution represents only an expression of opinion on the part of either house of Congress. It does not have the force of law, therefore it does not have required presidential approval. The process of amending the Constitution may start with a concurrent resolution. A vote censuring a representative or senator or any expression of sympathy takes the form of concurrent resolution. Section 8. Powers delegated to Congress. Congress shall have power. Clause 1. To lay and collect taxes, duties, imposts, and excise. To pay the debt and provide for the common defense, general welfare of the United States. But all duties, imposts, and excise shall be uniform throughout the United States. Section 8 places important powers in the hands of Congress, indicating that the framers of the Constitution were aware of the weakness of the Congress under the Articles of Confederation. The section lists 18 powers granted to Congress. The delegated are enumerated powers. The first 17 are express powers because they clearly designate specified areas in which Congress may exercise its authority. The 18th power is contained in the famous Elastic Clause, from which has come the doctrine of implied powers. The Elastic Clause permits the stretching of the other 17 powers. Clause 1. This clause gives Congress the power to levy and collect taxes, duties, or tariffs. Taxes are on import goods. Collections at custom houses. And excise, taxes on goods produced, sold, and consumed within the country. Excise, taxes on goods produced, sold, or consumed within the country. The term impost includes duties and excise taxes. Notice that these taxes must be uniform throughout the United States according to this clause. The power to tax may be used for two purposes only. 1. To pay the government's debts. 2. To provide for the common defense and general welfare. Social Security tax on payrolls is a present-day use of the power to tax. Clause 2. To borrow money on the credit of the United States. Clause 3. To regulate commerce with foreign nations among several states and with the Indian tribes. Clause 4. To establish a uniform trade of naturalization and uniform laws on the subject of bankruptcies throughout the United States. Clause 5. To coin money, regulate the value thereof, and of foreign coin, and fix the standard of weights and measures. 6. To provide for the punishment of counterfeiting the securities and current coins of the United States. Clause 2. The power granted Clause 2 enables the government to borrow money by issuing bonds for sale, on which the government pays interest. This clause, extended by Clause 18, has also given Congress the power to establish national banks and a Federal Reserve System. Clause 3. Clause 3 included to remedy one of the major weaknesses of the Articles of Confederation. Gives Congress direct control over interstate and foreign commerce. And this provision has been extended by the use of Clause 18 to give Congress control over transportation, communications, and navigation. In order to exercise this broad power, Congress had set up various administrative agencies, such as the Interstate Commerce Commission and the Federal Communication Commission. Clause 4. Clause 4 provides the power to regulate the methods by which aliens become citizens of the United States and to form rules regarding bankruptcy. Clause 5. Clause 5 permits Congress to coin money, to determine the gold and silver contents of money, and to order the printing of paper money. It also permits Congress to set up uniform standard for measures, weights, and distance. Clause 6. Under Clause 6, Congress authorized the Treasury Department to investigate counterfeiting of money or government bonds. Clause 7. To establish post office and post roads. 8. To promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Clause 9. To constitute tribunals inferior to the Supreme Court. Clause 10. To define and punish piracy and felonies committed on the high seas and offenses against the law of nations. Clause 11. To declare war, grant letters of marque and reprisal, and make rules concerning capture on land and water. Clause 7. Clause 7 grants Congress the power to control post office and the mail service through its power to appropriate money to run the various government departments, including the Post Office Department. Congress can also determine the postal rates. Clause 8. Clause 8 shows that the framers of the Constitution were eager to promote the progress of science and the arts. Under this power, Congress has passed laws providing that inventors be granted patents, exclusive rights to manufacture and sell their inventions for 17 years, and that authors and composers be granted copyrights, exclusive rights to control the publications or performance of their works for a 28-year period, renewable for an equal length of time. Clause 9. Clause 9 granted Congress the right to establish the federal district courts, the courts of appeal, and other special courts. Clause 10. Empowered by Congress. Empowered by Clause 10, Congress protects and controls citizens and ships of the United States when they are out of the country. It may also punish counterfeiting in the United States of bonds and notes of a foreign government. Clause 11. Clause 11 gives Congress the power to declare war. Although Congress alone has this power, there have been instances when presidents took military action without prior consent of Congress. In 1846, President Polk sent troops into an area which was claimed by both the United States and Mexico. Both the United States and Mexico. In 1950, President Truman ordered American troops into Korea to stop communist aggression. Letters of marque and reprisals were licenses issued by the government to privateers. Armed ships, privately owned, allowing them to attack enemy ships during wartime. In the War of 1812, many of these licenses were issued, and American privateers took advantage of them to do extensive damage to British trade. Today, this practice is outlawed by international agreement. Clause 12. To raise and support armies, but no appropriation of money appropriation of money to that use shall be for a longer term than 2 years. Clause 13. To provide and maintain a navy. Clause 14. To make rules for the government and regulations of the land and naval forces. Clause 15. To provide for calling forth the militia. To execute the laws of the Union. Suppress insurrection and repel invasion. Clause 16. To provide for organizing, arming, and disciplining the militia, and for governing such parts of them as may be employed in the service of the United States, reserving to the states, respectfully, the appointment of the officers and the authority of training the militia according to the discipline prescribed by Congress. Clause 12. The 2-year limit in Clause 12 on money appropriation for the Army was included to keep the major military power under strict civilian control. Clause 13. Notice that the appropriation for the Navy were not limited. An Air Force, of course, was not dreamed of when the Constitution was written. Clause 14. Under the power granted in Clause 14, Congress had established rules and regulation governing military discipline and the procedure of court-martial. Clause 15 and 16. The term militia now refers to the National Guard unit of the states. These units may now be called up by the President to keep law and order. They can become part of the United States Army in emergencies. Clause 17. To exercise exclusive legislation in all cases whatsoever over such districts not exceeding 10 miles square as may be, by sessions of particular states and the exceptions of Congress, become the seat of government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the states, in which the same shall be, for the erections of forts, magazines, arsenals, dockyards, and other needful buildings. The power in Clause 17 enables Congress to exercise exclusive control over the District of Columbia, as well as over forts, arsenals, federal courthouse, post office, muffin, dockyards, and other installations that are owned and operated by the federal government and the various states. Clause 18. To make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all powers vested in this Constitution and the government of the United States are in any department or officer thereof necessary and proper for carrying into execution the foregoing powers and all other powers vested in this Constitution and the government of the United States are in a department or office thereof. Necessary and proper are the key words in Clause 18, the so-called Classic Clause. Only by combining the powers granted in this claim with one of the other 17 powers can Congress use the implied powers granted to it in the Constitution. Laws based on this clause are, of course, subject to review by a judicial branch. Section 9. Powers denied to the federal government. Clause 1. The migration of importation of such persons or as any of the states now exist shall think proper to omit shall not be prohibited by Congress prior to the year 1808, but a tax on duty may be imposed on such importation not exceeding $10 for each person. Section 9 limits the powers of Congress. Clause 1. Such persons refers to slaves. This provision grew out of the compromise at the Constitutional Convention. It was agreed that Congress would not prohibit the importations of slaves prior to 1808, and that it would not impose or import taxes of more than $10 per slave. The importation of slaves into the United States was stopped in 1808. Clause 2. The privilege of the writ of habeas corpus shall not be suspended unless when in case of rebellion or invasion the public safety may require it. Clause 3. No bill of attainder or ex post facto laws shall be passed. Clause 2. The guarantee of the writ of habeas corpus, meaning you may have the body or person, has been called the most important single safeguard of personal liberty known to Anglo-American law. It protects a person against being held in jail on insufficient evidence or no evidence at all. The law of a person who is arrested can readily obtain a writ or court order which requires that the arrested person be brought before a judge who is to determine whether there are sufficient grounds to hold him in jail. If there are not enough grounds, the person must be set free. Clause 3. A bill of attainder is a legislative measure which condemns a person and punishes him without a jury trial. Such measures were used in England where Parliament could, by law, declare a person guilty of treason and punish him by death and confiscation of property. Under the Constitution, Congress cannot, by law, single out certain persons and inflict punishment on them. The power to punish belongs to the judiciary. An ex post facto law was a law which punished a person for doing something which was legal before the law was passed, or which increased the penalty for earlier actions. Because of this clause, the Lindbergh kidnapping law, for example, which was enacted by federal government in 1932, cannot be applied to persons who commit the crime or kidnapping before 1932. Clause 4. No capitation or other direct tax shall be laid unless in proportion to the census or enumerations herein before directed to be taken. Clause 5. No tax or duty shall be laid on articles exported from any state. Clause 6. No preference shall be given by any regulation of commerce or revenue to the ports of one state over those of another, nor shall vessels bound to or from one state be obliged to enter, clear, or pay duties in another. Clause 4. A capitation tax is a direct tax imposed on each person, such as the poll tax on persons voting. This provision was inserted to prevent Congress from taxing Negro slaves per poll or per person, for the purpose of abolishing slavery. Amendment 16 overrules this clause as far as income tax are concerned. Clause 5 also resulted from the Commerce Compromise. The Southern states wanted to make sure that Congress could not use its taxing power to impose taxes on Southern exports, such as cotton and tobacco. Clause 6. The United States is an open market in which all states have equal trading and commercial opportunities. Clause 7. No money shall be drawn from the treasure, but in consequence of appropriations made by law, and a regular statement and account of the receipts and expenditures of all public money shall be published from time to time. Clause 8. No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of the Congress, accept of any present, emolument, office, or title of any kind whatever, from any king, prince, or foreign state. Clause 7. This clause concerns the all-important power of the purse. Since Congress controls expenditures, it can limit the powers of the President by limiting the amount of money he may spend to run the government. This clause has been described as the single most important curb of presidential powers in the Constitution. Furthermore, the requirement to account for money spent and received helps to protect the public against misuse of funds. Clause 8. This clause prohibits the establishment of a nobility in this country. It is also intended to discourage bribery of United States officials by foreign governments. Section 10. Powers denied to the states. Clause 1. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisals, coin money, emit bills of credit, making anything but gold and silver coin a tender in payment of debts, pass any bill of attainder ex post facto laws, or law impairing the obligation of contracts, or grant any title of nobility. Clause 2. No state shall, without the consent of the Congress, lay any impost or duties on imports or exports, except what may be absolutely necessary for executing its inspection laws, and the net product of all duties and imposts laid by any state or imports or exports shall be for the use of the treasure of the United States, and all such laws shall be subject to the revision and control of the Congress. Clause 3. No state shall, without the consent of Congress, lay any duty of tonnage, troops, or ships of war in time of peace, enter into any agreement or compact with another state, or with a foreign power, or engage in war unless actually invaded, are in such imminent dangers as will not admit of delay. According to Section 10, states cannot 1. Make treaties, 2. Coin money, 3. Pass either bills of attainder or ex post facto laws, 4. Impair obligation of contract, 5. Grant titles of nobility, 6. Tax imports or exports without the consent of Congress, 7. Keep troops or warship in time of peace, 8. Deal with another state or foreign power without the consent of Congress, 9. Engage in war unless invaded. Clause 1. Because Shays' Rebellion was still fresh in the minds of the delegates to the Constitutional Convention, since several of the states at that time were being urged to pass legislation relieving debtors from the payment of their debts, the delegates decided to protect creditors once and for all by denying states the right to pass laws that would impair obligation of contract. During the Great Depression, which began in 1929, and the New Deal period, 1933 to 1945, the Supreme Court upheld state laws relieving debtors or mortgages from paying their debts on the due date. The payments were simply postponed, not canceled. Clause 3. States may enter into agreement or compact with each other, providing Congress approves. There have been many such arrangements among states on problems concerning port developments, conservation, minimum wages, crime prevention, flood control, pollution of rivers, lakes, and harbors, and other matters. Federal government, the federal system, division of powers. Federal government. Important and enumerated powers delegated to the Congress to regulate interstate and foreign commerce, to declare war, to establish laws governing citizenship, to coin money, to control the postal system, to regulate patents and copyrights, to establish lower courts, to establish and support the armed forces. Also, there are implied powers provided by the so-called Elastic Clause, Article 1, Section 8, Clause 18, granting the power to pass all laws necessary and proper to carry out the enumerated powers. Federal and state governments, important concurrent powers shared by federal and state governments, to tax, to borrow money, to establish penal laws, to charter banks, to take property for public purpose. The power is called eminent domain. state governments. Important residual or reserve power retained by the state's government to regulate suffrage, to maintain a system of public education, to establish marriage and divorce laws, to establish laws governing corporations, to establish traffic laws, to regulate interstate commerce. Also, according to the 10th Amendment, all powers, 1, not delegated to the federal government, 2, not prohibited by the Constitution, are reserved to the states or to this purpose, or to the people. Prohibited power. Powers deny the federal government to suspend the writ of habeas corpus except in cases of rebellion or invasion, to give preferential treatment to commerce or revenue to the ports of any state, to draw money from the treasury except by appropriation under a specific law, to levy taxes on exports. No person holding federal office can accept a gift from a foreign country without consent of Congress. Powers denied to federal and state governments. To pass bills of attainder, to pass ex post facto laws, to grant title of nobility. Powers denied to state governments. To enter into treaties with other nations or with other states without the consent of Congress, to coin money, to impair obligation or contract, to impair obligation of contract, to place a tax on imports or exports except to carry out its inspection laws, to keep troops or ships in time of peace without consent of Congress. Article 2, Executive Department, Section 1. President and Vice President. 1. Clause 1. Term of office. The executive power shall be vested in a President of the United States of America. He shall hold his office during the term of 4 years, and together with the Vice President, chosen for the same term, be elected as follows. This provision gives the executive power to the President. He may use all of the means at his disposal to carry out the laws. It should be understood, of course, that the power and prestige of the presidency depend to some extent on the personality of the man who holds the office. Clause 2. Electoral system. Each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress. But no senator or representative or persons holding an office of trust or profit under the United States shall be appointed an elector. Clause 3. Former method of using the electoral system. The electoral system. The electors shall meet in their respective states and vote by ballot for 2 persons, of whom one at least shall not be an inhabitant of the same state within themselves. And they shall make a list of all the persons voted for, and of the number of votes for each, which list they shall sign and certify, and transmit sealed to the seat of the government of the United States, directed to the President of the Senate. The President of the Senate shall, and the President of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes shall be President. If such numbers be a majority of the whole number of electors appointed, and if there be more than one who have such majority and have an equal number of votes, then the House of Representatives shall immediately choose by ballot one of them for President. And if no person have a majority, then from the 5 highest on the list, the said House shall in like manner choose the President. But choosing the President, the votes shall be taken by states. A representation from each state having 1 vote. A quorum for this purpose shall consist of a member or members from 2/3 of the state, and a majority of all the states shall be necessary to a choice. In every case, after the choice of the President, the person having the greatest number of votes of the electors shall be the Vice President. But if there should remain 2 or more who have equal votes, the Senate shall choose from them by ballot for the President. Clause 2 and 3, these clauses establishes the electoral system, but very little that the founding fathers decided about electing a president has survived in the form they intended. The delegates to the Constitutional Convention, still fearful of popular rule, decided that the President and Vice President ought to be elected by a small group of men called electors, chosen according to a method determined by each state legislature. Until Andrew Jackson's presidency, electors were chosen by state legislature. Since then, the people have voted directly for the electors. Some changes in the method of electing a president have been made by formal amendments, as in Amendment 12. Other changes have resulted from political practice. The method of electing a president today is shown in a chart entitled How a President is Elected, page 190. See also Amendment 23, page 196, for electors chosen by District of Columbia. Clause 4, time of elections. Congress may determine the time of choosing the electors and the day on which they shall give their votes, which day shall be the same throughout the United States. Clause 5, qualifications for president. No person except a natural-born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of the President. Neither shall any person be eligible to that office who shall not have attained to the age of 35 years and been 14 years a resident within the United States. Qualifications for President. 1. A native-born citizen of the United States. 2. At least 35 years of age. 3. A resident of the United States for at least 14 years. Term of office 4 years. Clause 6. Filling vacancies. In case of the removal of the President from office or of his death, resignation, or inability to discharge the powers and duties of the said office, the same shall devolve on the Vice President, and the Congress may, by law, provide for the case of removal, death, resignation, or inability, both of the President and Vice President, declaring what office shall then act as President, and such officer shall be accordingly, until the disability be removed, or a President shall be elected. If a President dies or is removed from office, the Vice President replaces him. John Tyler in 1841 was the first Vice President to succeed to the presidency. By assuming the office of President and not simply serving as an acting President, he established a precedent that since has been followed under the Presidential Succession Act of 1947. If both the President and the Vice President die or are removed from office, the order of succession is as follows. 1. Speaker of the House. 2. President pro tempore of the Senate. 3. Cabinet members in the order in which their offices were created. Clause 7. Salary. The President shall, at stated times, receive for his service a compensation which shall neither be increased or diminished during the period for which he shall have been elected, and he shall not receive within that period any other emolument from the United States or any of them. Clause 8. Oath of office. Before he entered on the execution of his office, he shall take the following oath or affirmation. I do solemnly swear or affirm that I will faithfully execute the office of the President of the United States, and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. Clause 7. In 1949, the President's salary was set by law as $100,000 a year, plus a $50,000 expense account, and a non-taxable fund for travel and official entertainment, limited to $40,000. The Vice President's salary was set in 1964 as $43,000 a year, plus a $10,000 expense allowance. Clause 8. The President assumes his office officially only after taking the oath of office, which is administered by the Chief Justice of the United States. Section 2. Powers of the President. Clause 1. Military powers. The President shall be Commander-in-Chief of the Army and Navy of the United States and of the militia of the several states when called into the actual service of the United States. He may require the opinion in writing of the principal officer in each of the executive department upon any subject relating to the duties of the respective office, and he shall have the power to grant reprieve and pardon for offenses against the United States, except in cases of impeachment. The important point in this provision is that it places the armed forces under the control of a civilian. The President is a civilian, but he is a superior in military power to any military officer. The words principal officer in each of the executive departments are the basis for the creation of the President's cabinet. Each cabinet member is the head of one of the executive departments. The President chooses his own cabinet. With the consent of the Senate, he can remove any cabinet official without asking Senate approval. Clause 2. Treaties and appointments. He shall have power, by and with the advice and consent of the Senate, to make treaties, provided 2/3 of the senators present concur. And he shall nominate, and by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers, consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior officers as they think proper. The President alone and the courts of law are in the heads of department. The President makes treaties with the advice and consent of 2/3 of the Senate. A treaty ratified by the Senate becomes the supreme law of the land. The President can also enter into executive agreements with foreign governments. Although such agreements may have the same force as treaties, they do not require Senate approval. With consent of the Senate, the President can appoint diplomatic officials, federal judges, military officers, and members of administrative agencies. Inferior officers are those subordinate to the cabinet members or to federal judges. At the present time, a majority of federal government positions are filled by candidates who passed examination given by the United States Civil Service Commission. Filling vacancies. Clause 3. Filling vacancies. The President shall have the power to fill up all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of their next session. If a vacancy in an important position occurs while Congress is not in session, the President has the power to fill it with an interim appointment. When Congress meets again, this appointment or a new appointment must be submitted to the Senate so that it may be approved. Clause 3. Duties of the President. He shall from time to time give to the Congress information of the state of the Union, and recommend to their consideration such members as he shall judge necessary and expedient. He may, on extraordinary occasions, convene both houses or either of them, and in case of disagreement between them, with respect to the time of adjournment, he may adjourn them to such time as he shall think proper. He shall receive ambassadors and other public ministers. He shall take care that the laws be faithfully executed, and shall commission all the officers of the United States. President duties include 1. Legislative duties, delivering annual and special messages to the Congress, calling special sessions of Congress, approving or vetoing bills. 2. Diplomatic duties, receiving or refusing to receive ambassadors or ministers of foreign countries to indicate that the United States recognizes or refuses to recognize the government of these countries. The President can also send home the ambassador of a foreign country as a sign that the United States is breaking off diplomatic relations with that country. 3. Executive duties, executing all the laws. Actually, the laws are carried out by the various government department commissions and administrative agencies, but the President is responsible for seeing that they are carried out. 4. Military duties, commissioning all United States Armed Forces officers. Section 4. Impeachment. The President, Vice President, and all civil officers of the United States shall be removed from office or on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Article 3. Judicial Department. Section 1. Federal Courts. The judicial powers of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their office during good behavior and shall, at stated times, receive for their services a compensation which shall not be diminished during their continuance in office. By authorizing the establishment of a system of federal courts, Article 3 creates the judicial power, the power to hear and decide cases. The lack of a federal court system was one of the weaknesses of the government under the Articles of Confederation. Under the judicial power granted by the Constitution, the courts have declared unconstitutional certain laws of Congress, acts of the President, laws of the state legislature, and decision by the state courts. Only the Supreme Court is established by the Constitution itself, but the Constitution gives Congress the authority to establish the lower courts which exist today. Since the Constitution does not state the number of justices to be appointed to the Supreme Court, Congress decides the number by law. At first, the Supreme Court had 6 justices. Congress has set the number at as many as 10 and as few as 5. Congress has created 2 types of lower courts. One type includes 91 federal district courts and 11 courts of appeals, which review cases sent up by the district courts. District courts and courts of appeals are called constitutional courts because they are general courts deriving their power directly from the Constitution. The second type of courts deal with cases of a specialized nature. The Court of Claims, the Tax Court, and the Court of Customs and Patent Appeals are included in the second group. The framers of the Constitution wanted to make sure that our federal judges would be independent of political influence. Accordingly, federal judges are appointed for life, subject to good behavior, and their pay cannot be reduced by law during their term of office. Section 2, Jurisdiction of Federal Courts. Article 1, General Jurisdiction. The judicial power shall grant to all cases in law and equity arising from this Constitution the laws of the United States and treaties made on which shall be made under their authority, to all cases affecting ambassadors, other public ministers and councils, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between 2 or more states, between a state and citizen of another state, between citizens of different states, between citizens of the same state claiming lands under grant of different states, and between a state or the citizens thereof and foreign states, citizens or subjects. Here the words law and equity have special meanings. Law means the common law. The laws that originated in England and that have been based on centuries of judicial decision. Equity refers to principles of justice also developed in England to remedy wrongs in situations in which the common law was inadequate. Today, in the United States, law and equity are applied by the same judges in the same courts. The power of the federal courts extend to 2 types of cases: those involving the interpretation of the Constitution, federal laws, treaties, and laws relating to ships on the high sea and navigable waters, and 2, those involving the United States government itself, foreign diplomatic officials, ambassadors, public ministers, and consuls. 2 or more state governments and citizens of different states when the sum involved is more than $10,000. Also cases involving a state or its citizens versus foreign countries or citizens of foreign countries. Clause 2, Supreme Court. In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. Original jurisdictions mean the right to try a case before any other court may hear it. Appellate jurisdictions means the right of a court to try cases appealed from lower courts. Most of the cases tried by the Supreme Court come up as a result of appeals from lower federal and state courts. Cases involving foreign diplomats in any of the 50 states, however, may be stated directly in the Supreme Court. Separation of federal powers. Examples of checks and balance. The legislative branch can impeach judges and change number of Supreme Court justices. Can refuse to confirm judicial appointments. Can propose amendments to overrule judicial decision. The judicial branch can declare laws unconstitutional. Legislative branch can impeach and remove president from office, can override president's veto. Senate can refuse to ratify treaties. Senate can refuse to confirm appointments. All right, the executive branch. President can veto bills and appeal to people in speeches. President can appeal to Congress in messages and can call special sessions. President has control of patronage. All right, the judicial branch. Can declare laws or executive acts unconstitutional. The executive branch to the judicial. Grants pardons and reprieves to federal offenders. President appoints Supreme Court justices and other federal judges. Clause 3, conduct of trials. Trial of all crimes except in cases of impeachment shall be by jury. Such trial shall be held in the state where the said crimes shall have been committed. But when not committed within any state, the trial shall be at such place or places as the Congress may by law have directed. Every person accused of a federal crime is guaranteed a jury trial near the scene of the crime, but the accused may give up this privilege if he wishes. Amendments 5, 6, and 7 expand the provisions of this clause. Section 3, treason. Clause 1, definition. Treasons against the United States shall consist only in leveling war against them, or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act or on confession in open court. Treason is the only crime specifically defined. Treason is the only crime specifically defined in the Constitution. To be found guilty of treason, a person must be shown to have helped wage war against the United States, or to have given aid and comfort to its enemies. A person cannot be convicted of treason unless the facts are proved either by the testimony of 2 witnesses to the same overt act or by confession in open court. Clause 2, punishment. The Congress shall have power to declare the punishment of treason, but no attainder of treason shall work corruption or blood or forfeiture except during the life of the person attained. The punishment for treason as determined by Congress is death or a fine of $10,000 and imprisonment for not less than 5 years. This clause further states that the punishment for treason cannot be extended to the children of a traitor. They cannot be deprived of their rights and their property as had been done in England. Article 4, Relations among the States. Section 1, Official Acts. Full faith and credit shall be given in each state to its public acts, records, and judicial proceedings of every other state. And the Congress may, by general laws, prescribe the manner in which such acts, records, and proceedings shall be provided, and the effect thereof. The purpose of this provision is to make sure that the official records of one state are respected in all the other states. Official records of this kind include birth, marriage, and death certificates, corporation charters, wills, and court decisions. This provision also protects a citizen's right to collect money that has been awarded him by a court's decision in one state, even if the person who owes him the money moves to another state. Section 2, Privilege of Citizens. Clause 1, Privileges. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. Clause 2, Extradition. A person charged in any state with treason, felony, or other crimes, who shall flee from justice and be found in another state, shall, on demand of the executive authority of the state from which he fled, be delivered up to be removed to the state having jurisdiction of the crime. Clause 3, Fugitive slaves. No person held in service or labor in another state, under the law thereof, escaping into another, shall, in consequence of any law or regulations therein, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due. Clause 1. The term privileges and immunities simply mean the rights of citizens. Thus, a state cannot discriminate against citizens of another state in favor of its own citizens, except in certain very special areas, such as voting, for example. A state can impose residence requirements for voting so that a citizen of another state will have to reside in the state for a specific period before he may exercise his right to vote as a citizen of his new state. Clause 2. This provision prevents a prisoner or person charged with a crime from escaping justice by fleeing across a state line, but provides that a criminal be returned by the state in which he is captured to the state where the crime was committed, a process known as extradition. A governor of a state cannot be forced to extradite or return a prisoner, however, if the governor feels that such action will result in injustice to the accused person. Clause 3. Since the ratification of Amendment 13 in 1865 brought an end to slavery in this country, this clause is now of historical interest only. Section 3. New states and territories. Clause 1. Admission of new states. New states may be admitted by the Congress into this Union, but no new state shall be formed or erected within the jurisdiction of any other state, or any state be formed by the junction of two or more states, or parts of states, without the consent of the legislature of the states concerned as well as of the Congress. The Northwest Ordinance of 1787 provided that new states be admitted to the Union on completely equal footing with the original 13 states. Although the Constitution declares here that new states may not be created within the territory of another state without its consent. In 1863, West Virginia was formed within the state of Virginia. This exception occurred during the war between the states, and West Virginia received permission from the loyal rather than the secessionist government of Virginia. Clause 2. Power of Congress over territories and other property. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory of other property belonging to the United States. And nothing in this Constitution shall be so constructed as to prejudice any claims of the United States or of any particular state. Under this provision, Congress has the power to control all property belonging to the federal government. It can set up government for territories and colonies of the United States. It can grant independence to a colony as it did to the Philippines in 1946. It can set aside land for national parks and build dams for flood controls. Section 4, guarantee to the states. The United States shall guarantee to every state in this Union a republican form of government, and shall protect each of them against invasion, and on application of the legislature or of the executive, when the legislature cannot be convened, against domestic violence. If the President finds that public property is being destroyed and the public safety is endangered in a state, may decide to send troops into that state without having been requested to do so by the local authorities. The President may even proclaim martial law to a state. Article 5, Methods of Amendment. Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution or on the application of the legislature of 2/3 of the several states shall call a convention for proposing amendments, which in either case shall be valid to all intent and purposes as part of this Constitution, when ratified by the legislature of 3/4 of the several states or by convention and 3/4 thereof, as the one or the other modes of ratification may be proposed by the Congress, provided that no amendment which may be made prior to the year 1808 shall in any manner affect the first and fourth clauses in the 9th section of the first article, and that no state without its consent shall be deprived of its equal suffrage in the Senate. One of the most important features of the Constitution is that it can be amended or changed. This adaptability is one of the 4 main principles of the Constitution. An amendment must first be proposed and then ratified. There are 4 methods of amending the Constitution. So far, all amendments have been proposed by Congress and ratified by state legislatures, except Amendment 21, which was ratified by the convention method. The fact that only 24 amendments have been adopted since 1789 and only 14 since 1791 indicate that it is not easy to change the Constitution, and that changing it is a serious matter requiring much thought and discussion in Congress, in the state legislatures, and among the people. Notice that there are 2 areas in which the Constitution cannot be amended under any circumstances. First exception is obsolete because it is a reference to the period which preceded 1808. The second exception is still very important because it guarantees that every state shall have equal representation in the Senate. Article 6, General Provisions. Clause 1, Public Debts. All debts contracted and engagements entered into for the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Federation. This provision was important because it announced to all that the new government would assume and pay back all debts incurred by the government under the Articles of Confederation. It was one of several actions advocated by Alexander Hamilton and undertaken by Congress in order to establish the credit of the new government. Clause 2. The supreme law. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby, anything in the constitution of laws of any state to the contrary notwithstanding. This is a famous supremacy clause of the Constitution. It declares that the supreme law of the land is 1. The Constitution, 2. The laws of the United States passed under this Constitution, and 3. The treaties made under the authority of the United States. According to the Supremacy Clause, the national government is superior in power to the states, provided its actions are in accordance with the Constitution. The Supreme Court determines whether the action of the President and Congress are constitutional. Clause 3. Oaths of office. The senators and representatives before mentioned, and the members of the several states' legislatures and all executives and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. But no religious test shall ever be required as a qualification to any office or public trust under the United States. No religious qualification shall ever be required as a condition for holding public office. This provision results from the fact that in the United States there is separation of church and state, and that a man's religion is considered to remain a private and not a public matter. How the Constitution may be amended. The House and the Senate. Amendments may be proposed by 2/3 vote of Congress, and both the House and the Senate are. 2/3 of state legislatures may request Congress to call a constitutional convention. Constitutional Convention proposes amendment. Then, amendment must be ratified by at least 3/4 of the state legislature, or by a majority vote, and 3/4 of state convention called to vote on amendment. Article 7, Ratification. The ratification of the Convention of 9 states shall be sufficient for the establishment of this Constitution between the states, so ratifying the same. The Constitutional Convention was summoned by the Congress under the Article of Confederation for the purpose of amending the Articles. According to the Articles of Confederation, amendments had to be approved by all 13 states. Instead of amending the Articles, however, the delegates to the Constitutional Convention drafted an entirely new plan of government. And realizing that it would be difficult to get the approval of all the states, Rhode Island, for example, had not even sent delegates to Philadelphia. Founding Fathers provided that the Constitution would go into effect after ratification by only 9 states instead of 13. As a result, some of the opponents of the Constitution argued that it had been adopted by revolutionary means. Done in convention by the unanimous consent of the states, presented the 17th day of September, the year of our Lord 1787, and of the independence of the United States of America, the 12th, in witnesses whereof we have hereunto subscribed our name. George Washington was the first President and Deputy of Virginia, New Hampshire. John Langdon, Nicholas Gilman, New York. Alexander Hamilton, Delaware. George Reed, Gunning Bedford. John Dickinson, Richard Bassett, Jacob Broome, North Carolina. William Blount, Richard Dobbs, Hugh Williamson, Massachusetts. Nathaniel Gorham, Rufus King. New Jersey, William Livingston, David Breedley, William Patterson, Jonathan Dayton. Maryland, James McHenry, Daniel of St. Thomas, Daniel Carroll. South Carolina, John Rutledge, Charles Coatsworth Pinckney, Charles Pinckney. Pierce Butler, Connecticut, William Samuel Johnson, Roger Sherman, Pennsylvania, Benjamin Franklin, Thomas Mifflin, Robert Morris, George Clymer, Thomas Fitzgibbons, Jared Ingersoll, James Wilson, Governor Morris. Virginia, John Blair, James Madison. Georgia, William Few, Abraham Baldwin. Act, the Stamp Act and the Townsend Act. In 1772, Adams started the Massachusetts Committee of Correspondence. In 1773, he helped to plan the Boston Tea Party. As a delegate to the First Continental Congress in 1774, Adams urged a complete breakaway from England. He subsequently was a signer of the Declaration of Independence. Adams later served as Lieutenant Governor 1789 to 1793, Governor 1794 to 1797 of Massachusetts. He died in Boston on October 2nd, 1803. The Albany Plan of Union, drafted by Benjamin Franklin 1709 to 1790. The Albany Plan sought to unify English colonies in America under a central administration for mutual defense. In the summer of 1754, shortly before the French and Indian War broke out, representatives from Massachusetts, Rhode Island, Connecticut, New York, New Hampshire, Pennsylvania, and Maryland met at Albany, New York, were chieftains of the Six Nations. Their prime objective was to consolidate Indian support against the French. This aim was realized only in part because the Iroquois were angry over colonial intrusions on their land. The colonists then considered Franklin's proposal to form a loose confederation of colonies under a central government. The Albany Plan called for a federal union administered by a president general appointed by the king and a council of delegates from the colonies. Each colony would retain its separate existence, but the new government would have broad powers over taxation, Indian affairs, conscriptions, ports, and vessels. The Albany Plan met with unanimous approval by the delegates, but it was rejected by the Crown, which feared that the Union would endanger English influence in America. It was also turned down by the colonial legislatures, which believed it would lessen their independence. Despite its rejection, the Albany Plan was an important forerunner of later attempts at unification. John Alden, 1599 to 1687. Alden, a copper, was hired by the Pilgrims at Southampton to repair the barrels aboard the Mayflower on its voyage to America in 1620. He was one of the signers of the Mayflower Compact and was one of the 8 men who assumed responsibility for the colonial debt in 1627. Shortly after the landing at Plymouth, Alden married Priscilla Mullins, daughter of a Pilgrim. The supposed involvement of his friend Miles Standish in their courtship was popularized in 1858 by Henry Wadsworth Longfellow in his poem The Courtship of Miles Standish. Alden became a farmer in Duxbury near Plymouth, and held a number of official positions in the colony. He was twice the governor's assistant and frequently served as acting governor. Alden outlived all the other signers of the Mayflower Pact. When he died in 1687, he was very close to Standish in Duxbury. Jean-Claude Aloquez, in 1658, Aloquez, Jesuit priests set up a